Major breaking news. We had a major argument in the United States Court of Appeals for the First Circuit based in Boston, Massachusetts, over whether or not the Commonwealth of Massachusetts so-called handgun roster is constitutional under the Second Amendment. This is a big deal because I think this is a very bad panel for the Second Amendment. However, strangely, there was some major pushback on the state of Massachusetts. Let's talk about it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gunner, constitutional attorney, member of the U.S. Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the four boxes of American liberty. Okay, folks, I want to give you a review of the 1 hour long oral argument in the First Circuit Court of Appeals case of Granata versus Campbell. The Granata case arises out of the Commonwealth of Massachusetts. It's a Second Amendment challenge to the constitutionality of the state's so-called handgun roster, which is very similar to the California handgun roster case. The biggest difference, as I see it for our purposes, I think is that the California roster might be a little bit more strict than Massachusetts because the California roster has the micro-stamping requirement that says that the gun you fire has to sort of micro-stamp the make and the model, and I think the serial number on the bullet or on the casing of the ammunition that's fired, which is not realistic. Massachusetts does not have that, but it does have a roster, and in both states, California and Massachusetts, they determine which guns are safe. If a gun is not deemed safe in Massachusetts, then it's not generally available to its citizens. The case of Granata versus Campbell was a case brought by the Firearms Policy Coalition, I believe, and the lawyer was Brad Benbrook. He was the one that argued the case and obviously did a very good job. The case had been appealed from the United States District Court for the District of Massachusetts. I should remind you that it was the Commonwealth of Massachusetts whose ban on stun guns gave rise to the U.S. Supreme Court's case of Caetano versus Massachusetts that said that stun guns were commonly owned and protected arms, even though they were invented in the 1970s. So there is some precedent here for Massachusetts anti-gunners to do things that ultimately give rise to very helpful pro-Second Amendment Supreme Court precedent. So keep that in mind as I talk about what happened at this argument. So the panel was a three-judge panel. David Barron, who was appointed by Barack Obama, Bruce Selya, appointed by Ronald Reagan, and Rogery Thompson, appointed by Barack Obama. In my view, and I've said this on Twitter and beyond, the First Circuit Court of Appeals out of Boston is, generally speaking, a terrible court, in my view, on Second Amendment issues. That's just my take on it. If just in terms of where I would like to see a case in the lower courts, it would never be in the First Circuit at all. With that said, sometimes you have to go to these bad jurisdictions and argue your way up and hopefully either get a favorable ruling, which you may not expect, which I'm not expecting here at the end of the day, or you get an adverse ruling that you can then use to go up to the United States Supreme Court. This was a very favorable argument as I see it, because a major argument on behalf of the Second Amendment plaintiffs here was that the firearms that had been banned meaning kept off the handgun roster by the state of Massachusetts, constituted a gun ban. And because the types of firearms, meaning handguns, that were being kept off the roster in Massachusetts, because those were in common use, and because handguns are obviously protected arms under the Second Amendment, that's what Heller specifically held, that we have a right to handguns under the Second Amendment. The handguns that are not on the roster are protected arms under the Second Amendment and cannot be banned. And as a consequence, this, when you apply the in common use test of Heller to the Massachusetts roster case, the roster should be declared unconstitutional because the effect of the roster is to ban in that state from Massachusetts residents, who obviously are protected by the Second Amendment because they're Americans, prevents them from having those arms that are in common use across the country in the United States. And that argument is, from what I can tell, was something that seemed somewhat receptive by the panel. And I'll tell you what was not, in my view, did not appear to be a particularly favorable argument with this panel. But with that said, this 3-judge panel really pushed Massachusetts extremely hard. And Massachusetts was trying to argue that this was not a gun ban, because again, if it's a gun ban, the in common use test applies. If it's not a gun ban, then you go into the historical analog analysis that Bruin talks about. And just as a reminder, the reason why you don't have to do the historical analog analysis in a gun ban case today, in the year of our Lord 2023, is because the Supreme Court already did the textual analysis and then the historical analog analysis of when you can and when you cannot ban firearms in the United States in the Heller case. So lower courts, such as the First Circuit Court of Appeals, just have to apply the Heller in common use test if it's a gun ban, because again, the work has already been done by the Supreme Court. There's no need to redo the work. With that said, Massachusetts desperately tried to argue this was not a gun ban case, that what this really is a form of products safety, consumer protection regulation. And they said that we just want to make sure that the guns that are sold in Massachusetts are safe for consumers. Now, we know this is a bunch of hooey. And why do I say it's a bunch of hooey? The anti-gunners in America do not get mad. Do not try to do gun control or ban guns, because guns don't work as intended, which means you pull the trigger and it fires a projectile. No, the anti-gun movement in America and states like Massachusetts are upset and try to restrict, regulate, and ban guns because they actually work exactly as intended. So when Massachusetts was, arguing that this is a consumer product safety issue to make sure that the guns sold in Massachusetts are safe for consumers, the panel was very smart. I will say this: the First Circuit, although they're, in my view, although they're not good on the Second Amendment, in my view, they are extremely intelligent. They're high IQ, very sharp individuals, very smart judges, and very serious people. So when I say they're not good on the Second Amendment, in my opinion, that does not mean they're not extraordinarily intelligent, because they're extremely smart judges and they're extremely smart lawyers and they're extremely credentialed on that court. So again, just so we understand that connection there. Now, so when the state of Massachusetts was arguing this is a consumer product safety issue, the panel really pushed back hard and is like, come on. They were not buying it, so they really seem to be very interested in the in common use argument, which, as you know from this channel, is something I've been saying all along, that those cases in California dealing with a handgun roster, at the end of the day, are really gun ban cases that simply requires the application of the in common use test and no need to do historical analog work because, again, the work has already been done. So to sum up, the way to view this case, and we're going to find out about who wins this case in the First Circuit Court of Appeals probably in the next 4 months. But again, we don't know what this court's going to do. I'm not optimistic, but anything can happen. These judges are smart, and maybe they will feel that they have to follow the law by the Supreme Court. But I'm guessing in about 4 months, we'll be doing a video and I'll be explaining to you. I told you so. Great argument. We had the better argument. We have the better facts, in my view, in this case. But we lost in this panel, and then we'll be seeing whether or not that will be going to the U.S. Supreme Court or not in the fall. But only time will tell. Okay, folks, I hope you learned a little bit something here today at the Four Boxes Diner. If you haven't subscribed, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.